May it please the Court, my name is James McCartney, and I represent Appellant Female Incorporated in this matter. I would like to ask to reserve 2 minutes of my time for rebuttal. Thank you, Your Honors. Female Incorporated respectfully asks this Court to reverse the trial court's decision in granting plaintiff's motion for summary judgment. The issue before the Court today is whether being of the female sex is a bona fide occupational qualification for a Chicago-based taxi company that caters primarily to female passengers seeking the peace of mind that could be provided by female drivers. Your Honors, Female Inc. will clearly show that being female is in fact a bona fide occupational qualification for employment with Female Incorporated, so that the business is able to continue serving the customers whom the appellant has set out to serve in their community. In order for an employer to establish a bona fide occupational qualification, there are 3 elements that must be met, and Female will show that all 3 have in fact been met. The first element to be proven is that there is a factual basis for believing that hiring any members of one sex would undermine the essence of its business. It is to state that there is a factual basis for believing that hiring any members of another sex would undermine the essence of its business. The second element to be proven is that the asserted privacy interest is entitled to protection under the law. Third, that no reasonable alternatives exist to protect the privacy interests that have been asserted other than a gender-based hiring policy. So a brief recitation of the pertinent facts. Mr. Tyler Gill, the plaintiff of the original case at bar and now the appellee, had completed an online application with Female on September 16th, 2021. The next day, on September 17th of 2021, Mr. Gill received a notice from Female Inc. that it had received his application and would not be offering him employment. Female had asserted that they did not offer Gill a position based on the fact that he is a male. Now, I think it's critical here to point out that in the record, we have testimony from multiple individuals as to why it was that they use Female as a taxi company, why it is that they choose a solely female-driven taxi as their source of transportation. First, we hear from Brittany Tiergarten in Exhibit C, who had cited that she works at a bank in downtown Chicago. She was sexually assaulted in her days at college on a date with a male in his car, and then she was forcefully removed from that car while the perpetrator in that case had driven off. The police were not able to locate him, and it was found that the information that he had given to Ms. Tiergarten was in fact falsified. From that point on, she was nervous. She did not want to be in a car alone with a male driver for fear of that attack being replicated by another male. Generally speaking, she would avoid the use of taxis as transportation because she did not want to be alone with a male. She did at one point seek a taxi ride from a male, but at that point found herself having a panic attack. After that point, she made an effort to not use taxis more strenuously so than she had previously. And at the inception of Female Incorporated, as both an application on the phone and as just a business more broadly, she exclusively uses Female Inc. for that sense of security that is provided, as she had stated, by female drivers. We also see in Exhibit B from Maris L.F. Farrell, someone who works at a downtown Chicago law firm, who was stalked by a male taxi driver. She had received a ride home from this individual, and then she went upstairs to her apartment in Chicago, and found that when she went down the next morning, that driver in the same taxi vehicle that she had received a ride from him in, he was still waiting there for her to come out of her apartment. And that stalking behavior persisted. She contacted authorities and was informed by the authorities that since the individual had not committed a crime, the police could not take any action against this individual. Now, these kind of interactions, these kind of experiences that female passengers have asserted that they've had, is such that they do not want to replicate, and exactly why they're such strong and ardent supporters of Female Incorporated. And they're exactly the type of demographic that Female has targeted, and the reason why Female has asserted this bona fide occupational qualification of female-only drivers to provide that sense of security to passengers similar to those that I had mentioned just previously. Ultimately, what this case is about the right of a company to provide a sense of safety, a sense of peace of mind, and to protect the mental state and health of its clientele, of its passengers. And it's ultimately about being able to permit a company in the marketplace to provide and address the needs of its community. And here in the present case, it's the ability of Female Incorporated to safely provide transportation to female passengers who are seeking a better sense of security, safety, and peace of mind by making use of female-only drivers. Now, the law that we'll be examining today it was established by the Civil Rights Act of 1964, 42 U.S.C. Section 2000E-2E1, which states that it shall not be an unlawful employment practice for an employer to hire and employ employees on the basis of sex in those certain instances where sex is a bona fide occupational qualification reasonably necessary to the normal operation of the particular business or enterprise. As I mentioned earlier, to make sure that, or to enable such a defense to stand up, there are three elements that must be proven. First, and we'll address here, is that there is a factual basis for believing that hiring any members of one sex would undermine the essence of the business. In the present case, it would be that hiring males as drivers for Female Incorporated would in fact undermine the essence of its business. And is contended here that in fact it would, as the sole essence and purpose for the business operating in the first place is that it provides female-only drivers to offer a sense of safety, peace of mind, and security to its largely female clientele. Now, 85% of Female's clients and customers are female, and they use that service for the very purpose that Female offers readily available female drivers. As we saw in the Norwood case, as I cited in my brief here, a defendant in a privacy rights case has to satisfy its burden of proving a factual basis for sex-based hiring by showing that the clients or guests of a particular business would no longer consent to using that service if it was run or if it was mainly operated by members of the opposites of a particular sex. In this case, male drivers. Now, as I noted earlier, the two affidavits, both Exhibit B and Exhibit C, those customers, I think, provide quite the example for showing such a need for female drivers, and that the sole reason that they utilize Female Incorporated is because they offer readily available and exclusively female drivers. Additionally, as we look at prong number 2 that must be proven here. We have to establish that the asserted privacy interest is in fact entitled to protection under the law. And here it is. It is in fact entitled to protection under the law. And one major point I want to draw attention to, as our case is different from a very major case, namely Diaz versus Pan Am, which was a case in which a male airline employee had sought employment with Pan Am Airlines, not too dissimilar from our present case, and was rejected on the basis of his sex. And the reason being that Pan Am held was that female flight attendants were far better at providing a comforting environment to passengers by what the court had deemed the tangential and non-mechanical aspects of the job, of being able to comfort, to ease the stress of the flight transportation to its passengers. That is different here for multiple reasons. In our present case, we do not have the presence of multitudes of other passengers. On an airline, generally, in general parlance, we understand that it is more than exclusively one passenger, where there is a far more intimate setting between the operator of the vehicle or the pilot of the airline and the passenger. On an airline, we clearly know that from experience that there are many, many other passengers to limit potential exposure or harm from a flight attendant or from a pilot. In a taxi cab, it is very often the case that it is solely one passenger and one driver, which presents the opportunity for potential assault by a male driver on a female victim. Furthermore, in the Norwood versus Dale maintenance systems, the court noted that those occupations which require an employee to work with or around individuals whose bodies are exposed in varying degrees are eligible for the bona fide occupational qualification defense. In this present situation of a taxi driver and a passenger, it is the case that a driver is exposed to the body of another in a very private and semi-intimate setting, and that it is an enclosed structure that holds two individuals, presenting the threat of the driver being able to impose some sort of dangerous situation upon the passenger in an unwilling manner. The third prong that female will prove is that no reasonable alternatives exist to protect the privacy interests other than gender-based hiring. We have no alternatives here in this case. It is strictly that a female driver must be operating the vehicle because cameras, security shields between the front and back seats do not prevent the potential of an assault. Every assault begins, or every criminal assailant must have that first offense. And here, there is no alternatives present to truly deter or prevent that from happening. And to that, we look to the Sedita case that presented a gym with female-only clientele and ruled, and the court had declined to comment on whether or not reasonable alternatives would be efficient for the business. And I see my time here is running out. So I would like to conclude by thanking your honors and noting that if it please the court, that Female Incorporated has in fact met the three elements required by the bona fide occupational qualification exception to Title VII. Thank you for your time, and I appreciate your listening to our presented case here today. Thank you.